Welcome. I will be reading the Saskatchewan Police Act 1990, the current version as posted on July 5th, 2018. Thank you so much. My name is Dale Lakeman. It's great to be here.
The only other question I'd like to ask you is if you mind giving your opinion on this. Do you think that uniformed RCMP members should investigate complaints against other RCMP members? Do you think that if I complain about the police, do you think that a uniformed RCMP member should come and investigate a complaint?
Against that person, like you're talking public complaints?
Yeah. Do you think uniformed RCMP officers...
He said no. Just got to adjust my focus a little bit here. There we go. So, 1990 Act respecting police services, assented June 22nd, 1990. Her Majesty, by, with, and advice and consent of the Legislative Assembly of Saskatchewan, enacts as follows. Part 1. Title, Interpretation. Act may be said as a police act. In this act, the board means with respect to a municipality, where the municipality has established a board of police commissioners, pursuant to Section 27, the Board of Police Commissioners. Where the municipality has not established a board of police commissioners, the council. Chief means the chief of police appointed pursuant to Section 35. Civilian member means a civilian employee or police of a police service. Commission means the Saskatchewan Police Commission continued pursuant to Section 3. Commissioner means a member of the commission. Council means the council of municipality. Department means the department over which the minister presides. Hearing officer means a hearing officer appointed pursuant to Section 17. Investigator means the complaints investigator appointed pursuant to Section 16. Local Police Association means a bargaining unit as determined by the Labor Relations Board. Member means a member of the police service and, unless otherwise specifically provided, includes police, the chief of police, an officer, a non-commissioned officer, a constable, and a special constable, unless otherwise indicated in his or her appointment. Member at large means a member of the board police commissioner appointed as a member at large pursuant to Section 27. Minister means the member of the executive council to whom for the time being, the administration of this act is assigned. Municipality means, unless otherwise specifically provided, an urban municipality within the meaning of the Urban Municipality Act 1984 that has a population of at least 500, or a northern municipality within the meaning of the Northern Municipalities Act that has a population of at least 500. Officer means a member who holds a rank of inspector or above. Personnel means the members and civilian members employed within a police service. Police service means a police department, police service, or police force established by a board. Regional police service means a police service established pursuant to Section 28. Part 2, Administration, Saskatchewan Police Commission. The Saskatchewan Police Commission is continued. The commission is constituted as a body corporate. The head office of the commission is to be at a place in Saskatchewan designated by the Lieutenant Governor in Council. Lieutenant Governor in Council may create a seal for the commission. Police, 1990. Members of the commission. Members of the commission. Members of the commission. Members of the commission. The commission is to consist of not less than 3 commissioners to be appointed by the Lieutenant Governor in Council. Each person appointed as a commissioner shall hold office at pleasure for a term not exceeding 3 years. shall continue in office until successor is appointed and may be reappointed. No person shall be appointed for more than 2 successive terms. The Lieutenant Governor and Council shall designate a commissioner as chairperson and another commissioner as vice chairperson. The chairperson may designate a member of the commission to exercise any of the powers conferred or to perform any of the duties imposed. Oath of office. Before entering on the duties of office, a commissioner shall take a prescribed and subscribe to an oath or office or affirmation in the form prescribed in the regulations before a person authorized to administer an oath or affirmation. Remuneration. The commission shall pay to the commissioners a remuneration determined by the Lieutenant Governor in Council and reimburse commissioners for traveling and living expenses at rates determined by the Lieutenant Governor or the Council. In Council. The Commission may employ any employees. This is staff. The Commission may employ any employees that the Commission considers necessary for the purposes of its operations. To determine duties, powers, and conditions of employment and remuneration of the employees mentioned in Clause A. Enter into agreements to engage the services of persons or agencies it considers necessary for the purposes of its operations. Police and engages. So this is more staff. Engage the services of persons who have special technical or other knowledge to advise and report on matters related to the purposes of the Commission, and pay remuneration and reimburse the expenses of the persons mentioned in clauses C and D. The Public Service Act, the Public Service Superannuation Act, the Superannuation Supplementary Provisions Act apply to the persons employed to pursuant to Clause 1A. The Commission may establish and support any employee benefit program for the benefit of the employees of the Commission and dependents of those employees. Orders of the Commission. The chairperson or in absence of the chairperson, a vice chairperson shall sign any order, consent, certificate, or other document issued or made by the Commission. An order, consent, certificate, or other document purporting to be signed in accordance with subsection 1 is admissible in evidence as prima facie proof of the facts contained in the order, consent, certificate, or document in any court or tribunal conducting a hearing pursuant to this act without proof of the signature or official character of the person. Without proof of the signature or official character of the person who signed the order, consent, certificate, or document. The Commission may hold sittings at any place in Saskatchewan that it considers appropriate. The Commission shall make rules respecting practice and procedure before the Commission and may prescribe forms for that purpose. Each Commissioner has all the powers confirmed on a Commissioner pursuant to the Public Inquiries Act. The Commission may pay any witness or interpreter it requires to attend to an inquiry or hearing those fees and expenses that would be payable to a witness or interpreter pursuant to the Court Queen's Bench fees regulations. No action against the Commission. No action against the Commission. No action against the Commission shall be instituted against the minister, shall be instituted against the department. No action, guys, no action. No action lies or shall be instituted against the minister, the department, the commission, a commissioner, a hearing officer, the investigator, or any persons employed or engaged by the commission or the investigator where the minister and department. Look at that. See that? See the way the page is missing? Do you see that? You see where that's missing, guys? See that's missing right there? It says 10. It says 10. You see that? So section 10 is missing, guys. It's gone. Section 10 is missing. See that? That's section 10. This is one of the most important parts for citizens to know. And you see section 10 is missing. You see that? You see the way it's cut off? See, the page is cut off. There is. I'm not kidding you, right? I'm not kidding you. I can't kid you a bit on this. I can't kid you. But section 10 is cut right out, guys. No action lies or shall be instituted against the minister, the department, the commission, a commissioner, a hearing officer, the investigator, or any person employed or engaged by the commission or the investigator where the minister, department. You see that? The line, it's cut right off. There's no, it's cut off. It's cut, right? You see this bottom of this page, right? You see that? It's not cut off, right? You see that, right? It's not cut off, but here it is. And this is section 10, right? And regulations, right? And you see that it's cut off. We can't see what that says. This is a public document that should not be edited or redacted in any way for any reason, right? So no action lies or shall be instituted against the minister or the department. Section 10. This is section 10 of the Police Act. No action lies or shall be instituted against the minister. So you can't sue them. You can't. They don't have any responsibility. They're impudent. They're impudent. And look, it's cut off, so we can't read the document. This is the Canadian Law Library, guys. I want you to make sure you know. This is it, right? This is the Police Act. This is the official document released to the public, and you see that. It's cut off. It's cut off. We can't read it, right? No action lies with or shall be instituted against the minister, the department, the commission, a commissioner, a hearing officer, investigator, or any person employed or engaged by the commission or the investigator where the minister, department, what? 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 Where's the sentence? And then it goes on to say, of anything in good faith done, cause permitted or authorized to be done, attempted to be done, or omitted to be done by any of them, pursuant to or in the exercise of supposed exercise of any power conferred by this act or the regulations, or in the carrying out or supposed carrying out of any order made pursuant to this act, or any duty imposed by this act and regulations. So this is section 10. Remember, this is the section 10 that we're talking about, right? This is it right here. And you'll notice now that it's deliberately cut off. There's no anyone that does anything credible, it's not cut off, right? It's not cut off, right? This is what the problem is, guys. There's a big problem with accountability.
Are left with no answers to their questions and significant concerns over the transparency over any accountability for the police.
When they keep a tight lid over this kind of incident and say the issue has been referred to the Saskatchewan Serious Incident Response Team, and therefore that's the full explanation we're going to give you, you're setting up what I would consider a protectionist ring. The legitimacy of the police service itself becomes questioned. People begin to wonder if they are really there for them and if they might be treated that way.
Yeah, it's a conspiracy. It's racketeering. It's a protection racket. That's what the Complaints Commission is.
There's a systemic problem with accountability for police officers, and the Crown Prosecution Service is a major player in that.
So we So now we know that lawyers Not in Saskatchewan, though, but mind you, remember, because we mean, Alberta lawyers, these are both Alberta lawyers, Tom Engel and, oh, darn it, now I forgot his name. But these are Alberta lawyers. Those were aired on CBC. Both of those interviews were aired on CBC. And of course, we know how it is when a person can just do whatever they want to do without any kind of responsibility, right? Right? We know, right?
Well, maybe they fight sometimes for good
happens.
reasons, but very frequently they fight for bad reasons. And those bad reasons are personal as well as sociocultural and economic. Whatever pathologies you were carrying around in your destructive little soul, whatever element of Cain was deeply embedded in you, had the opportunity to be manifest fully at every moment of your waking existence, right? You had these people who were completely beholden to you, with no rights whatsoever, to whom you could do whatever your evil little heart determined.
So, of course, everyone says, well, we do things in good faith, right? We mean to do right. But look, it's obvious that they've even eliminated part of the document. They haven't even put up, this is the Canadian Law Library. Remember that this is a document that's presented, in Saskatchewan. And it's already, it's cut in half. We can't see what it fully says, right? This is section 10. This has to do with accountability of police officers and the Complaints Commission and the accountability, right? So it says, no action against the commission, etc. No action, section 10, no action lies or shall be instituted against the minister, Christine Tell, the department, attorney generals, anyone, the commission, a commissioner, the senator, commissioner, a hearing officer, so anyone sitting around, any investigator, any person employed or engaged by the commission or the investigator. So remember, FSIN is engaged by the commissioner and by the investigator. You know what for, right? To be the person that represents a racialized person. So First Nations person, yes, you do have representation in a certain sense. It's from the FSIN. And you notice that most First Nations people will say, without the FSIN, I'd have no support. Well, it's true. And so they have even omitted the part of the document, part of section 10. Okay, so commissioners, any department of anything in good faith done. Yeah, well, are we believed? Do we believe these people are acting in good faith when they won't be accountable? What do you mean? How can a person act in good faith when they're not accountable even if they lie? That doesn't make sense. Oh, even if you lie, it's okay. Well, so I'm acting in good faith, like to avoid a riot. Okay, so I'll just lie to them, and then people won't know that the cops murder people, right? Because if the cops knew that these people were being murdered, if the public knew that that police were murdering people, well, of course there'd be a riot. So the commissioner can say, well, we're not disclosing that information because it's a danger to the public, because somebody could get mad and riot. There could be outrage, there could be protests. So to avoid protests, to avoid outrage, well, we just don't say anything. We just don't disclose anything, right? That's what they do. That's why they're not disclosing, is because there could be riots. People could be mad. And you don't want a bunch of people walking around being mad. So of anything in good faith done, so they do it in good faith. Well, there could be a riot. If we say that the cops actually murdered this person, okay, so we get the family to say, okay, we admit to the family to a certain respect, liability or accountability. Why? Because we're going to just say, hey, look, we understand. We're going to give you, some money, maybe, because a lawyer comes in and tries to intimidate them. But if you talk to them, or if you don't have FSIN, well, God help you, because you know what's going to happen to you. You're going to get gang stalked, and that's what's going to happen. There's no question about it, because this is what happens when you complain to the police about the police. This is what happens right here. This is what happens. And so that's what happens when you complain about the police in Saskatchewan right there. So if anything in good faith done, caused, permitted, or authorized to be done, it caused, happened, attempted to be done, or omitted to be done by any of them pursuant or to or in the exercise of or supposed exercise of any power conferred by this act or regulations, or in the carrying out of supposed carrying out of any order made pursuant to this act, or any duty opposed by this act or the regulations. Commissioners are not compellable. So you cannot compel the commissioner to actually say what the truth is. You cannot do that. It's not legal. The judge will say you, well, under Section 35. Okay, so a commissioner or a person employed or engaged by the commissioner is not compellable in any civil proceedings. You cannot sue these guys for lying. You can't sue them for just saying, well, we dismiss your complaint, for not doing their jobs. They cannot be compelled. Is not responsible or compellable in any civil proceedings to testify with respect to any information obtained in the discharge of his or her duties pursuant to this act, or to produce any files, papers, information, reports, correspondence, or other documents relating to the business or activities of the commission. So they do not have to disclose. That's the non-disclosure. The commissioners don't even have to say, even whatever they have on their mind, they don't even have to say. Regulations of the commission, subject to the approval of the lieutenant governor in council, the commission may make regulations prescribing minimum standards for selection and training members, prescribing a police training program for members. See, this is something that they always say, but this is in the Police Act. These are the exact quotations from the Police Act. Okay, this is the Police Act. And so when they say, well, this is our report, it says, well, we need minimum standings for the selection and training of our members. Okay, that's in the Police Act already. That's something that's supposed to be already being done, but it's not being done. Prescribe a police training program for members, any category of members. Well, that's not being done. Prescribe an orientation program and code of ethical conduct for board of members. Yeah, that's being done, but they don't follow it because, like, we'll go back just a couple seconds here, not compellable. Not actually, not cost, no actions or lies. No action lies, no culpability, no responsibility, right? So the regulations of the commission, subject to the approval of the lieutenant governor in council, the commission may make regulations prescribing minimum standards. These are all the things that they keep repeating, right? But there's never anything done, right? Prescribing minimum standards for selection training of members, prescribing police training program minimums. These are the minimums, right? Prescribing police training program for members, any category of members, prescribing orientation program, ethical conduct for board members. Prescribing communication system for all or any police services and regulated the operations and procedures of the communication systems. Prescribing the minimum number of members a municipality shall employ on the basis of population area, any combination of factors mentioned in paragraphs A and B, or any other basis, or on the basis of any combination of the factors mentioned in subclause I and II. Prescribing records, returns, books, and accounts to be maintained by police. What? F. EF. Okay, GH is missing. EFGH, and then it goes to I. You see that? Okay, it's F. So we can't read this part. It's redacted. This document's not complete to the public. GH is missing, right? So GF is missing. G and H is missing, guys. So we can't even read what they say. Prescribing requirements respecting clothing and equipment to be provided to police services by municipalities. So this document's already not full, right? It's not complete, right? It's not complete. You see, it's not complete, and it's not complete on purpose, right? It's not complete on purpose. You see that? Prescribing the records, returns, books, and accounts to be maintained by the police. Blah. What? F. G H I E F. F. Here's F, G H, and then I. But G H is missing. So we don't have a fully complete document because we can't, right? And remember, this is the Canadian Law Library, right? This is the document, right? This is the Canadian Law Library document, right? Right? This is the government document that concerns, like for public, you can read this. This is where you get your information from. So establishing a uniform disciplinary code for all police services, including the procedure to be followed in hearing and determining breaches of discipline, unsuitability, or incompetence. Prescribing offenses under any code established pursuant to Clause J, and the penalties that may be administered. L, providing for and prescribing rules respecting appeals with respect to discipline, breaches of conduct, suspensions, or dismissals from employment. They can't be dismissed. Prescribing terms and conditions respecting financial aid to boards, councils, police services, training police for education programs conducted or approved by the Commission, and members to participate in programs described in subclause I. Prescribing the minimum number of meetings to be held by boards, prescribing any matter or thing required to authorize by this act to be prescribed in the regulations, prescribing any other or thing that considers it's necessary to fulfill its duties or exercise its powers pursuant to this act, making regulations pursuant to subjects 1. The Commission shall inform the boards, the Saskatchewan Association of the Chiefs of Police, Saskatchewan Federation of Police Officers, and the proposed regulations, and provide an opportunity for the boards, the Association of Police Chiefs, Saskatchewan Federation of Police Officers, to make representation to the Commission with respect to proposed regulations. But it does not mention public input at all. Okay, prior to making regulations, the Commission shall inform the boards, the Saskatchewan Association of Chiefs of Police, and the Saskatchewan Federation of Police Officers of the proposed regulations, and provide an opportunity for the boards, not the public, never the public. The Association of Chiefs of Police, we're not public, those aren't public members, they're not public people. And the Saskatchewan Federation of Police Officers, that's not public, to make representations to the Commission with respect to the proposed regulations. No public input. Public input is not being allowed right there. The fiscal year of the Commission is commenced on April 1st when they kill somebody. They kill Bowden on April 1st, 2023. In 1 year and ending March 31st, the next year, the provincial auditor or any auditor or firm of auditors that the Lieutenant Governor and Council may appoint shall annually and at any other time that the Lieutenant Governor and Council may require audit the accounts of the Commission's the annual report. The Commission in each fiscal year, in accordance with the Tabling of Documents Act, shall prepare and submit to the Minister a report of the Commission on its business for the preceding fiscal year. The Minister shall, in accordance with tabled documents, lay before the Legislative Assembly each report received pursuant to Subsection 1. The Lieutenant Governor and Council shall appoint a person as complaints investigator. The Lieutenant Governor and Council shall appoint a person as a complaints investigator. I should be the complaints investigator, guys. I should be the complaints investigator, or you should be. Maybe you should be complaints investigator. Public should be the complaints investigator. We should have a board of 5 public people assigned as a jury, just selected out of a jury pool. Every complaint should be inspected by 5 public citizens selected out of a jury pool. All the information should be sent. That's what should happen. All the information should be sent to 5 individual citizens. Every citizen should be able to put a response to that complaint in, and then it should be juried. It should be a jury of citizens. The Lieutenant Governor shall appoint a person as a complaints commissioner. Should be me. Should be you. The investigator shall perform any duties imposed by this act or any other act on the investigator or specified by the Lieutenant Governor and Council. Where the investigator is sick or otherwise unable to perform the duties of the investigator, the Lieutenant Governor and Council may appoint another person acting as an investigator. The absence of an investigator, the acting investigator shall perform the duties imposed on and may exercise powers given to the investigator. Section 5, 7, 13, 14, 15 of this act apply with any necessary modifications to the investigator. Section 17, hearing officer. The Lieutenant Governor and Council shall appoint 1 or more persons who, at the date of their appointment, have been members in good standing of any law society. Saskatchewan, we do not have a law society. We have an unlaw society. The lawyers, Saskatchewan Law Society is nothing but an association for like representing like corruption, who at the date of their appointment have been members in good standing of any law society of one of the provinces of Canada for the immediate preceding 5 years, or have been members of the judiciary as hearing officers. Oh my God. Police. A hearing officer shall perform any duties imposed by this act, regulations of any other act or hearing officer, or specified by the Lieutenant Governor and Council. Where a hearing is held with respect to a member of a police service, the board responsible for that police service shall pay all the expenses and conduct a hearing, including transcription expenses, pay the hearing officer remuneration determined by the Lieutenant Governor and Council, and reimburse the hearing officer for expenses at rates determined by the Lieutenant Governor and Council. A hearing officer has all the powers confirmed and conferred to the Commission pursuant to the Public Inquiries Act. Part 3, Policing and Public Services Minister and Commission. Ministerial responsibility. The minister shall promote adequate and effective policing throughout Saskatchewan and the preservation of peace, the prevention of crime, the efficiency of police services, and the improvement of police relationships with communities within Saskatchewan. The duty and the powers of the Commission. The Commission shall promote adequate and effective policing throughout Saskatchewan and the preservation of peace, the prevention of crime, the efficiency of police services, and the improvement of police relationships with communities within Saskatchewan. In fulfilling its responsibilities pursuant to Section 1, the Commission may develop and maintain programs to create understanding of police functions, and so then we're missing B. Right? We're missing all those sections and Part B because this document's never going to be fully complete, right? It's never will be. C, facilitate the coordination of police activities on a provincial and municipal basis to ensure uniform law enforcement and optimum cooperation between police services and other services. Operate the Saskatchewan Police College and provide for the training of members. Conduct audits and reviews of police services to ensure that police services are provided and meet the requirements of this act. Develop and supervise training programs for members or categories of members. Compile and distribute to boards, chiefs, police services, a policy and procedure instruction manual subject to regulations, provided financial aid to boards or police services for police training or education programs conducted or approved by the Commission, and members to participate in the programs described in subclause I. Establish and maintain a central information and statistics service for all police services in Saskatchewan. Government to provide the police services, provincial policing. Government of Saskatchewan shall cause policing service to be provided in rural municipalities within the meaning of the Rural Municipality Act 1989, Northern Saskatchewan Administration District. Pardon me. Other than in towns within the meaning of the Northern Municipalities Act, have population at least 500, subject to the approval of the Governor General. The Minister, on behalf of the Government of Saskatchewan, may enter into an agreement with the Government of Canada to employ the Royal Canadian Mounted Police to aid in the administration of justice and enforcement of laws enforced in Saskatchewan, where an agreement has been entered into pursuant to subsection 1. Now we're missing whole second, where we're missing the whole Part 2. The Royal Canadian Mounted Police are responsible for policing all or any, and of course document parts missing, because this is continuous, right? Its parts are missing in this document continuously. They don't disclose to the public even the document. Police, notwithstanding subsection 2, the Royal Canadian Mounted Police are not responsible for policing in a municipality unless there is an agreement made pursuant to section 22 or 23 respecting that municipality. During the period of agreement entered into subsection 1, members of the Royal Canadian Mounted Police are peace officers and shall fulfill the duties and may exercise the powers conferred by any act or law or on police officers and constables with respect to the preservation of peace, prevention of crime, and enforcement of laws in force in Saskatchewan. Provincial municipal agreement, where an agreement has been entered into in subsection 21, 1. The minister on behalf of the government of Saskatchewan may enter into an agreement with the municipality having a population of 1,500 or less for the services of the Royal Canadian Mounted Police in aiding the administration of justice and providing policing services within the municipality. During the period of an agreement entered into subsection 1, members of the Royal Canadian Mounted Police shall fulfill the duties and may exercise the powers conferred on constables or police officers by the municipality or any act or law enforcement in Saskatchewan. Federal municipal agreement subject to the approval of the Lieutenant Governor and Council. A municipality having a population more than 1,500 but not more than 20,000 may enter into an agreement with the Government of Canada to employ and pay for a sufficient number of members of the Royal Canadian Mounted Police to provide policing services within the municipality. During the period of an agreement entered into subsection 1, members of the Royal Canadian Mounted Police shall fulfill the duties and may exercise the powers conferred on constables or peace officers by the municipality or any act or law enforcement in Saskatchewan. Emergency policing. And then we miss a whole bunch, right? Right? Then there's a bunch missing. Pardon me. And then it goes on to say, the Lieutenant Governor and Council in order may make provision for the employment of the Royal Canadian Mounted Police to provide police services to the municipality or at any time the Lieutenant Governor and Council considers advisable. Where an order is made pursuant to subsection 1, the Lieutenant Governor and Council by order may direct the municipality to pay the government of Saskatchewan any amount the Lieutenant Governor and Council considers necessary for police services. Where the municipality refuses or neglects to pay the amount required pursuant to subsection 2, that amount may be deducted from any grant payable by the government of Saskatchewan, may be recovered by any action in any court of competent jurisdiction as a debt due to Her Majesty and the right of Saskatchewan. Municipality is responsible for policing. A municipality is responsible for the maintenance of law and order within its boundaries and shall provide policing services to maintain a reasonable standard of law enforcement and shall provide adequate and reasonable facilities required for the policing services mentioned. Establishment of a police service agreement for policing. Municipalities shall establish their own police service or enter into an agreement with the government of Saskatchewan pursuant to Section 22 of the Government of Canada, pursuant to Section 23, to have policing services provided by the Royal Canadian Mounted Police. Where a municipality establishes its own police services, the police service is to consist of a chief and any other personnel that the board considers necessary. And of course, we're missing parts, see, still, right? Bam. Has a population of under 5,000, has established a police service, shall establish by bylaw, Board of Police Commissioners of a community that has a population of 5,000 or less and has been entered into agreement pursuant to Section 22 or 23 to have its policing, may establish by bylaw a Board of Police Commissioners. A board established pursuant to Section 1 or 2, and it's a body corporate. A board is to consist of either 3 board members or 5 board members appointed annually by the council and include the mayor of the municipality, and where the board consists of 3 board members, 1 member of the council in addition to the mayor, and 1 other person other than a member of council as a member at large, and where the board consists of more than 3 board members, 2 members of council in addition to the mayor, and 2 other persons, other members of council as council members at large. Subject to subsection 6, a board member other than the mayor holds office for the term prescribed in the bylaw and until a successor is appointed. Where a board member holds an office as a member of the council, loses office as a member of the council. A board member also loses office as a board member. If provided in the bylaw, any board member may be reappointed for a further term in accordance with the bylaw. A board shall appoint 1 of the board members to be chairperson and another board member to be vice chairperson. Where a vacancy occurs on the board of the council, within 1 month of the occurrence of the vacancy shall appoint a person to be a replacement former member for main term of the former board member. Police, where a board member other than the mayor is ill or otherwise unable to perform his or her duties, the council may appoint a person to act as the illness or inability of that board member during the illness or inability of the board member. Where the mayor is ill or otherwise unable to perform his duties, the person appointed as presiding officer of the council shall act instead of the mayor and shall fulfill the duties of and may exercise all the powers conferred on and during the illness or inability of the mayor. Where a board consists of 3 board members, 2 board members constitute a quorum, and more than 3 board members constitute a quorum. A council may provide for the payment of a reasonable remuneration to each board member and any person appointed to act during the absence or illness of a board member. Subject to section 15, subsection 15, the board shall hold its meetings open to the public. Not true. Subject to section 15, the board shall hold its meetings open to the public. Not true. The board may conduct meetings relating to contract negotiations, personnel, security, and specific police operations in private. So they don't have to have the public there. That's what dispels it, like takes away that other one right there. Before entering on the duties of office, board members shall take and prescribe to an oath or affirmation in the form prescribed in the regulations before a person authorized to administer an oath or affirmation. We know how well those are. There's no accountability. You know, section 10 has already told us that. So each board member has all the powers conferred on the commission pursuant to the Public Inquiries Act. Regional police agreement, subject to the approval of Lieutenant Governor and Council. 2 or more municipalities enter into an agreement between themselves to have one regional police service provide police service in those municipalities. Or, see, look at that. And so they add, so they keep going, right? They don't necessarily have to cut it off, but they do, right? Where the region to be policed pursuant to the agreement includes an area described in section 20 that's not within the geographical limits of those municipalities, enter into an agreement with the minister, and if the area is a rural municipality within the meaning of the Rural Municipality Act, with the minister responsible for an administration of that act, and if the area's municipality has a population of less than 500 or in the Northern Saskatchewan Administration District other than in a town with the meaning of the Northern Municipalities Act and has a population of at least 500, with the minister responsible for the administration of the Urban Municipality Act on behalf of the government of Saskatchewan to have one regional police service provide policing services in those municipalities and in that area. As soon as reasonably possible after entering into an agreement pursuant to subsection 1, a municipality shall confirm its participation by bylaw. No municipality shall withdraw from an agreement described in subsection 1 without the approval of the Lieutenant Governor. Regional Police Board, subject to regulations, parties in agreement mentioned in section 28 shall establish a regional police board in accordance with the agreement. The appointment of a regional police board member may only be revoked for cause and in accordance with the agreement entered into section 28. Before entering the duties of office, a regional police board member shall take and subscribe to an oath or affirmation in the form prescribed in the regulation before a person authorized administration, oath or affirmation. And we know that those do no good at all, right? Oaths do not, or affirmations, they do not. Like you don't have to tell the truth. There's lies there. Before entering on duties of an office, shall take an oath. Subject to the agreement entered into section 28, this act and the regulations other than those provisions of this act and the regulations prescribed in the regulations apply to, we don't know. We have no idea, right? They apply to what? I mean, guys, if you can't, like, why are you cutting off? You're cutting parts out of this. Subject to the agreement entered into sections 28, without limiting the general of subsection 4. A regional police board established pursuant may exercise the powers conferred and shall fulfill the duties imposed on a board pursuant to this act, and a member of the regional police service established pursuant to section 28 may exercise the powers conferred and shall fulfill the duties imposed on a member pursuant to this act. Regional board responsibilities. A regional board, on behalf of the parties to an agreement entered into pursuant to section 28, is responsible for delivering of policing services within this area specified in that agreement and providing general direction, policy, informations, priorities, and developing long-term plans for the regional police service. Where a municipality board is responsible for the police. Where a municipality has established a police service pursuant to subsection or section 26, the board is responsible for the delivery of police service within the municipality and for providing general direction, policy, and priorities, and for the and developing long-term plans for the police service. For the purpose of this act, the Trade Union Act, the board is deemed to be employer of the personnel of the police service, and the chief or any person holding a position of deputy chief of the police are deemed to be agents of the employer. And of course, it's cut off, right? So we're in section 31, it's cut off. We missed part, right? Okay, civil action against a member. Civil action against a member. Where a claim for damages is made or a civil action is instituted against a member as a result of an act committed while acting in the scope of employment as a member, the employer of the member shall retain and pay for the services of a legal counsel to act on behalf of that member. Pay any sum required in connection with a judgment or settlement of a claim for damages and costs awarded against the member. So there you go. They have lawyers for the police because the police are, like you said, are not accountable. So where a claim for damages is made, civil action is instituted against a member as a result of an act committed while acting in the scope of employment as a member. The employer of the member shall retain and pay for the services of a legal counsel. So they have to buy a lawyer, they have to get a lawyer for that person, which is public prosecution's office, and act on behalf of that member and pay any sum required in connection with the judgment or settlement of a claim for damages and costs awarded against the member. Financial estimates on or before the day set by a bylaw. A board shall submit to the council for the council's approval the board's estimates of all monies the board requires for the next fiscal year and for the board and police services. Where the council does not approve the estimates submitted by the board, the council shall immediately cause the estimates to be returned to the board together with their council's reasons for not approving the estimates. Where the estimates are returned pursuant to subsection 2, the board shall submit more revised estimates to the council for the council's approval. If the council does not approve of the revised estimates submitted pursuant to the subsection, the council shall determine the gross amount of the estimates, and the council's determination is final. When the council has approved the estimates or determined the gross amount of the estimates, the board shall submit a copy of the estimates to the commission. No board shall, without the prior approval of the council, authorize expenditure of any monies in excess or the gross amount of estimates approved by council, or authorize any expenditure of monies for any matter or purpose not included in the estimates. Board of Advisory to the Royal Canadian Mounted Police, where, pursuant to Section 22 or 23, an agreement exists between a municipality and the government of Saskatchewan for the Canada employment of the Royal Canadian. See that? It's cut off again, guys, because they don't provide full explanations or full documents, right? Part 4 and sections 83 to 85 do not apply to the Canadian Mounted Police, and the board shall act in advisory capacity and any member in charge of the Royal Canadian Mounted Police detachment responsible for providing the police services. The chief of police, where police service is established pursuant to section 26, the board shall appoint a chief of police. Subject to the general direction of the board to this act and the regulations, the chief is responsible for administration, management, and operation of the police service, maintenance of law and order in the municipality, and maintenance of discipline within the police service. To carry out the responsibilities imposed on a chief of police as acted by the regulations, the chief may appoint any personnel to positions designated by the board and assign their duties. Delegate to any member or civilian member any authority vested in the chief that, in the opinion of the chief, is required to properly manage the police service, and make directives necessary to carry out daily administration and operations to the police service. Members, before entering on the duties of a member of the police service shall take the prescribed oath or affirmation, which we know just anyone can just say, yeah, I'll be a good cop. I'll be a cop. Sure, for sure. Anybody would, any job. I'll be a good mechanic. In the form prescribed in the regulations before a person authorized to administer an oath or affirmation. Do you swear to God? Yeah, sure, why not? unless otherwise indicated in his or her appointment, a member has the power and the responsibility to perform all duties that are assigned to constables or peace officers in relation to the preservation of peace, the prevention of crime and offenses against the laws in force in the municipality, the apprehension of criminals, offenders, and others who may be lawfully taken into custody. And then, of course, it's blocked off. It's cut off again, guys. We don't get the full. And so we miss section B totally. We go to C, right? The document's not complete. And this is the Canadian Law Library. You know, I want you to know this is what we're looking at, right? The Canadian Law Library, guys. That's what we're looking at. And it's cut off, right? It's cut off. It's cut off. See? Cut off. Civil action against a member where claim for damages is made or civil action is instituted against a member as a result of an act committed while in the scope of employment as a member. The employer of the member shall retain and pay for services of a legal counsel to act on behalf of that member. Saskatchewan Public Prosecutions is responsible to represent the police against any complaint. So if the police officer lays a charge of obstruction, anything, the Public Prosecutions Office is responsible to defend the police officer. Did you get it? If a police officer lays a charge against a person, fair, unfair, right? So if they lie, if they fabricate evidence, if they do anything, the Public Prosecutions Office is appointed to act on behalf of the police against citizens. And the Public Prosecutions Office has a responsibility to citizens to prosecute people that break the law. And police determine who broke the law. Only a police officer can lay a charge. Public prosecutions represents police officers when they lay charges against anyone, any citizen. If a citizen complains about the police officer, the Public Prosecutions Office represents the police officer. So if a police officer charges you with obstruction, there will be no representation on behalf of you. Like, you do not get represented in any action against a police officer. And only a police officer can lay a charge, right? Only the judge, after you're acquitted, can say you're acquitted, but you still can't sue the police officer or the people that have provided statements in a false charge. Kosher fabricated a charge with Melissa Jones. My neighbors attacked me, and they charged me with creating a disturbance. They had to withdraw that because it's a travesty, Tony. The Attorney General, and they took me to court for that, because only a police officer, and you can only be acquitted by a judge. And the Public Prosecutions Office, that's why there was no legal aid lawyer, because legal aid it's a contract. They represent the government, and they do what the government says. That's why I couldn't get a lawyer, because the Law Society in Saskatchewan, it doesn't represent the public, it represents the lawyers. So if you complain even to the Law Society about a judge or even a lawyer, there is no public representation against any wrongdoings by any judge, any commissioner, any investigator of a complaint. There is no responsibility. Neil Meyer came. Obviously, it was kosher. They forced me to sign a complaint. Now, if you're sitting there with a guy that's got guns on their waist and you know that you're going to get fucked over, do you just say, okay, I know I'm getting fucked over. I've got to go along with this because they have guns? Because Keith Kosher said, you kind of have to be nice to me, Dale. They coerced me. You can see that they forced me. Even the Reverend was apprehensive to do this, but he did it. They all did it. Should I just go and sue the Reverend? What is the Reverend going to say? And what will the court say to me? Bullshit, right? Bullshit. What happened? They tried to kill me. Where a claim for damages is made or a civil action is instituted against a member as a result of an act committed while acting in the scope of employment as a member, the employer of the member shall retain and pay for the services of a legal counsel to act on behalf of the member and pay any sum required in connection with the judgment or settlement of claim for damages costs awarded against a member. That's why it's non-disclosure, because they'll just say to you, look, we're not going to admit responsibility, but we understand that you've gone through some, okay? So we're just going to say, you guys want this money, or do you want to actually try to sue us with the lawyer? And if the family of Bowden will say, well, God, we can't sue you. The lawyer that acts on behalf, FSIN, will say, take the money. They're offering you money, but if you go and try to sue them, A, you can't sue them. B, the Saskatchewan government, everybody represents, every Saskatchewan government person represents that police officer and backs them up, even if the charge is wrong, even if they killed somebody. The whole government goes behind them because A, B, C, if you hire a cop and you tell them, if you do kill somebody, you're going to get sued, there won't be any cops. Nobody would want to write a wrong ticket and then get sued for $1,500 and have to pay $1,500 because he wrote a speeding ticket, right? So Seal, if he goes and writes a bunch of mean-spirited tickets, just because he wants to get 1 million tickets, and that's what he did. It was on Twitter that he was going to set a world record for giving out distracted driving tickets. You can look it up. Constable Michael Seal was trying to set a world record for giving out distracted driving tickets. He gave out 1 million tickets, guys, in Saskatchewan. There's only fucking how many? 12 million people in Saskatchewan. That's why he got shut down. But he's got no. Kosher came and fucking harassed me for 15 years. Neil Meyer tried to murder me on behalf of Kosher. So they charged me. Legal aid won't defend me. It wouldn't have defended me. Why? Because they're contracted as well. And legal aid is not responsible to defend a person, no matter who they are. They can refuse to represent anyone at any time. There is no legal aid appointment. You have to ask the judge to appoint a lawyer. The judge appointed a lawyer to cross-examine the witnesses. The lawyer didn't even contact me. I said, I have a list of questions. I have some subpoenas. They told me, well, you have to do that all yourself. You'll have to present that. Or they told me to present my list of questions to the prosecution so that they can submit it to my lawyer. What? They told me to make my own subpoenas and deliver them. That's not, they lied. That's not legal. The office of the clerk is responsible. If I give them a list, I gave them a list of 6 people that I wanted to call, and they said, you have to make these out yourself. You have to pay for serving these people. You have to hire an independent server, a person that, and it was all a lie. They lied, and they're not responsible. They're not responsible because they lied, because they have a contract. Where a claim of damages is made, a civil action is instituted against a member, any member of the Law Society. There is no Law Society. There is no ombudsman, guys. There is no Human Rights Commission in Saskatchewan. Retain and pay for the services of a legal counsel to act on behalf of those people. And to pay, because that's what they do. They say, sign this, non-disclosure, we're going to give you money. And if you don't, well then, fuck you. On or before a day set by any law, board shall submit to the council for the council's. I think that's about all we really need to do, right? Is show you guys that, look, the document's never going to be complete. The chief is required to properly maintain this, but the chief can't be sued. Where a claim for damages is made, civil actions instituted against member result of the committed act while acting in scope of employment of member, the employer, the member shall retain and pay for the service of legal counsel, act on behalf of the member, and pay any sum required in connection with the judgment and settlement of claim, damages, costs awarded to member. On or day set before the bylaw, the board shall submit to the council for the council's approval. The board estimates all monies the board requires for the next fiscal year before the board and police service. Where the council does not approve the estimates submitted by the board, the council shall immediately cause estimates to be returned to the board together with the council reasons. Where the estimates are returned, the board shall submit revised estimates to council's approval. If council does not approve the revised estimates, submitted section in council shall determine the gross amount of this estimates, and the council's determination is final. Where the council has approved the estimates or determined the gross amounts of the estimates, no board shall submit a copy of the estimates to the commission. No board shall, without a prior approval of the council, authorize expenditure of any monies in excess of the gross amount of the estimates provided by the council or approved by the council. Authorize any expenditure of monies for any purpose not included in the estimates. Board advisory to Royal Canadian Mounted Police. Where 34, where section 2223 an agreement exists between a municipality and the government of Saskatchewan or Canada for the employment of the Royal Canadian. What? Do you know what I mean? This is supposed to be the Canada Law Library, guys. That's what we got going on here, okay? I want to show you guys one time. See that? This is the Canada Law Library, and that's how insufficient this document is to the public. And you know why? Do you know why? It's for one reason. Well, they don't want you to know what they don't do for you. And the other reason is like, why bother? The public doesn't read these documents. You don't know that you have no rights, do you? I mean, it's better for you to not know that you have no rights. So Part 4 and Sections 83 and 85 do not apply to the Royal Canadian Mounted Police, and the board shall act in advisory capacity to any member in charge of the Royal Canadian. See, like the board is sub to the Royal Canadian Mounted Police, right? Providing the police services. Where police services, chief of police, where the police services established pursuant to Section 26, the board shall appoint a chief of police. Subject to the approval, the general direction of the board, and to this act and the regulations, the chief is responsible for the managed administration, operation of the police service, maintenance of law and order in the municipality, and maintenance of discipline within the police service. So how can we sue the police? Because we can't sue the chief. We can't sue the chief who's responsible for this, right? And it's a trickle-down responsibility of non-culpability. So it's a trickle-down responsibility of non-culpability. The chief is not culpable. The chief is not responsible for his responsibilities, right? It says he's responsible, but he doesn't have, he has immunity, right? He is not culpable for the responsibilities. To carry out the responsibilities, the maintenance of discipline within the chief is responsible. Maintenance of discipline, the chief's responsible. Carry out the responsibilities imposed on the chief by this act and the regulations. The chief may appoint any personnel or positions designated by the board and assign their duties. So he assigns his investigators of his police officers, Delegate to any member, a civilian member, an authority vested in the chief that an opinion of the chief is required to properly manage the police service. Make directives necessary to carry out daily administrations and operations. Members, before entering on the duties of member, a police service member shall take a subscribed an oath and affirmation in form of the prescribed regulations before a person authorized. So, hey man, are you gonna work for us? Yeah, okay. You believe in God? Well, I mean, you don't have to, but will you swear to God? Sure, why not? Yeah, I mean, geez, I mean, I've got this contract that says I'm not responsible, so why wouldn't I sign this? Why wouldn't I agree to anything you want me to do? Because I'm not responsible for anything I do. Perform all duties that are assigned to constant, unless otherwise indicated in his or a member has the power and the responsibility to perform all duties that are assigned to constables or peace officers in relation to the preservation of peace, prevention of crime and offenses against the laws, apprehension of criminals, offenders, and others who may lawfully be taken into custody or unlawfully taken into custody. That does not matter because look, there's parts missing, right? Part B is missing, guys. Why is Part B missing again? This is a public document that's supposed to be fully, completely accessible for us to read. For us to read. Why is Part B missing? That's what I'd like to see. I mean, are you that lazy that, oh, the page was too long, so I didn't include it? Like, what do you mean? This is supposed to be a public document. Why is it missing, guys? Why? Because it says any police officer can enforce the law in any way and charge anyone with any law and not be responsible for lying about it. That's what Part B says, guys. Part B says that the police can charge you and they're not responsible if they're wrong in charging you, because you go to court and you are adjudicated in front of a judge. He decides whether the charge was right or wrong. Police officers could come here and say that I'm threatening them right now, and hey, I'll have to go to court for 5 years, guys. I'll have to go to court for 5 years again, guys. And then, hey, so they waste $500,000, $600,000 taking me to court for 5 years after I complained about them. Who paid that money? Who paid the money? Who cares? You paid the money. The judge didn't care. Tony Garine didn't care. Alan Gerrits doesn't care. Kelly Green didn't care. I'm sitting here for 2 years. Nobody gives. You're right, Alex Benz. You're right, my subscribers. Nobody cares. Okay, until you're dead and your mom is crying about you. Then she might care. Maybe. But I don't have any family to give a fuck about me. So, hey, that's why I'm doing this. Because if they kill me, nobody's going to fucking care. But you might hear this, right? Maybe you're going to be scared now of the police. Are you guys going to be afraid of the police? Are you going to be scared of the police now that they can just do whatever they want? And so police members can perform all duties that may lawfully be performed by constables or peace officers in relation to escorting, conveyance of persons, lawful custodies, courts, confinement, correctional facilities, hospitals. They can take you anywhere they want, do whatever they want to you. Unless otherwise indicated by the member's appointment, a member has authority to exercise the powers and performed in the duties subsection 2 throughout Saskatchewan. Any police officer can lay a charge. Any judge can acquit you, but you have to wait till you get into court. God, that's not threatening, intimidating, and unfair, is it? Oh, you don't get a legal aid lawyer because why? Because public prosecutions represents the police officer, even if he's wrong. We already went over that in this police act. Okay? In the police act, we've already seen that. Exercise the powers and perform duties mentioned in subsection. They're impudent and immune to any wrongdoing. They can kill you. They can kill me. They can kill anyone. And trust me, you can't do fuck all about it, buddy. Interpretation of part of internal discipline. Internal means that you keep your shit inside. You discipline yourself is what it really means. But internal disciplines means systemic discipline. Internal discipline means disciplinary proceedings initiated within the police service. Service discipline. You know, you don't have to actually maintain your integrity or discipline as an officer. You can go and just beat the fuck out of people. You know, you can kill people. That's okay, because you're not responsible for what you do, because you're just, you know, I don't know. Are you crazy, or just like, are you just playing dumb so that you can play dumb? Internal discipline means disciplinary proceedings initiated within the police service. Major disciplinary offense never happens. Means an offense designated in the regulation is a major disciplinary offense. So, of course, that section was missing, right? Member does not include the chief. Member minor disciplinary offense. Minor disciplinary offense means an offense designating in the regulations is a minor disciplinary offense, which is very broad, very broad, very broad. You could hit somebody in the head and cause them brain damage. That could be considered minor because like what the police officer, what anybody would say, well, the guy was going to hit me, so I had to hit him. Oh, okay, so that's minor then because he was going to hit you. You felt threatened. Okay, well, that's fair. But if I'm a citizen and somebody tries to hit me and I hit them, I could be charged with assault, but not a police officer. Public complaint. A public complaint means a complaint initiated by a member of the public outside of the police service, where the prosecution, the public prosecutions office, represents the police in a public complaint. Remember, public prosecutions office represents the police. So if a police officer charges you with a wrong charge and you say, well, they're lying, you can go all the way to court, and if the judge acquits you, okay. But otherwise, the police can lie. They can charge you with some kind of offense where your neighbors come across the street and threaten you. And then the police come. I mean, I've got the film, right? My neighbor, I mean, hold on a second here. My neighbor comes across the street, I'm sure. I could spool it up here for you. My neighbor comes across the street and attacks me, guys. My neighbors come and attack me, guys. And of course, the police charge me, right? The police charge me, right? The police charge me, right? That's what happens, right? I mean, we can go through this whole fucking thing for another 4 or 5 hours, and then we can go through some more of this, but I'm going to tell you. So my neighbors attacked me. Kosher comes along and fucking threatens me, right? And charges me, eh? But my neighbor attacked me, guys.
Here,
my neighbor attacked me.
I know what he looks like.
No,
and he was
this is what happened, guys.
I don't know what he was yelling. But it was obviously a threat. He's obviously acting pretty threatening. He's definitely afraid to come in, though. Poor guy. And he shouldn't be. He's a tough guy. Look. Toughness proof.
RCMP.
Hi, how are you?
I'm fine, how are you?
Could be better, could be worse. Unfortunately.
How can we help you there?
Pardon me?
How can we help you there?
Yeah, my neighbor across the street threatened me just now. And
Where are you calling from?
Fillmore.
What's your address, sir?
94 Main Street. Dale Lakeman?
No, sorry, what was that?
Dale Lakeman is my name.
Oh, Dale, okay. Gotcha.
Dale.
And do you have a phone number there, Dale?
Oh, no, I don't. I have a Google phone. Sorry. He ducks out of the way because he knows where the camera's aimed. They always like to have the rookie.
So Melissa Jones comes and charges me with causing a disturbance when Gary did that to me. I phoned immediately. Talked to the dispatcher. Melissa Jones comes 3 or 4 weeks later, right? Charges me with causing a disturbance. And the same thing happened here, right? This is the exact same.
Yeah,
thing.
what time is it?
Exact same.
It's am I breaking any laws?
My neighbor comes running at.
Loud, your truck's loud. Just like you, right now with your camera, filming me. Your camera. Yeah, because you're obnoxious.
Yeah, and he was complaining that my mufflers are loud, and you can hear my bike right there, right? It's not loud at all. It's stock Yamaha pipes. It was Harleys that were loud. My neighbor's bikes were loud, or are loud still, I'm sure. Okay, so any kind of minor or major disciplinary offense, doesn't matter. Even if, here's the evidence. Yeah, here's the evidence. They lied. They harassed me. But it's okay because, there's no responsibility. There's no culpability. So complaint made, member of the public may make a complaint at any police station, board, office, affected police service, the office of the investigator, or the department. And so you see, the whole section is missing again, right? So you can't fully get the whole information. A person who receives a public complaint shall record the complaint, blah, 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 procedures that will be followed. Inform the person and the rights of appeal pursuant to this act, which, see? So the whole section is missing again. So if you want to look this up and you want to know how the complaint system works, you have to tell me. You have to talk to me because I know how it works, right? Right? I know how it works. You don't. You can sit there. You can come over to my place, 1510 Broadway Avenue, and I'll tell you how it works. A person who receives a public complaint with respect to the chief shall immediately transmit the complaint to the board and provide copies to the investigator, the department, and the chief. No public complaint shall be received pursuant to this section after the expiry of 6 months from the day on which the complaint should have been aware of the incident complained of. Duties and powers. Where the investigator receives a public complaint pursuant to Section 38, the investigator shall record the complaint received, establish, maintain, and record all public complaints received by police services and their dispositions, advise and assist complainants, advise and assist the chiefs, the boards, and hearing officer in the commission with respect to handling of public complaints. Monitor the handling of public complaints, ensure that public complaints are handled in a manner consistent with the public interest, because public interest lies with the police, boys. Inspect annually or at those times directed by the Minister of the Records, Operations Systems Administration for handling of public complaints by the police services and exercising the duties of investigator pursuant to the section. Investigator shall receive and obtain information respecting a public complaint from the complainant. May receive and obtain information respecting a public complaint from the member of the chief who is the subject of the complaint. The chief or the board or any manner investigator considers appropriate. May request access to any files or any other material in possession of the police service relevant to the public complaint, and may interview and take statements from the chief, board, complainant, and the member of the chief who is, or the chief who is subject of the complainant, member, or the chief. Where they, okay, so, and then C2, A, B, C, D, 3. See, it's okay. It's consistent sometimes, but very inconsistent when it comes to to try to pin these guys down. They don't want to reveal the full form. Remember, this is the Canadian Lie Library. Lie Library, remember. That's what this is. Where the investigator has requested access to files or other material pursuant to Clause 2C, the police shall comply with that request. Where a board, police service member, or chief refuses to comply with the requests made pursuant, the investigator may apply to Her Majesty's Court of Queen's Bench for an order compelling the board, police service chief, or member, which is rarely granted, to comply with the request, even because, they're buddies anyways. So even if they just like play paperwork, right? Play paperwork is what this is called. Subject to this act and the regulations, investigators shall hold all information obtained pursuant to Clause 2C in confidence. Of course, they will not reveal what's written, what's in there. Investigators shall not provide a complainant. The investigator shall not provide a complainant with any information regarding a complaint which may jeopardize a police investigation. So if this cop says to you, look, I've charged this guy with harassing me. I've charged this guy with obstruction. So we don't have to even tell him what we think of his complaint, right? If they charge you, then they will not tell you how wrong they are, right? When the board of police service member refuses, shall hold all information obtained pursuant to Clause 2C in confidence. The investigator shall not provide a complainant with any information regarding a complaint which may jeopardize the police investigation. And we know that the police investigate their own public complaints. And if the police officer is investigating a complaint on behalf of the complainant, that means he's investigating, and he does not have to give you information, even if you're the complainant. Subject to subsection 8. No oral or written statement received by the investigator shall be used or received as evidence in any civil proceeding. So even if they say, even if I say, they won't even use my complaint in a civil proceeding or any, it can't be disclosed to a civil lawsuit in any proceeding under any act. So even if a judge says, hey, I want this complaint in public, they do not have any responsibility or reason to jeopardize their investigation of the complaint. They do not have to give you the information that they're finding out about the officer. The officer maybe had shot people. Maybe he's gone crazy and beat people up. Maybe he's solicited prostitutes. We don't know. He could be doing anything. He could be accused of racism multiple times. If you complain about racism, if you complain about anything, they don't have to disclose what he's done before. His prior record is never disclosed. No oral or written statement received by the investigator shall be used or received as evidence in any civil proceeding, in any proceeding under any other act. Even if he gets charged with a crime, they cannot reveal his history of complaints against him, right? He could be charged with murdering me. He could be charged with murdering you. But if he's had 100 complaints against him, that cannot be admitted into any record. The guy could be charged with murder. They'd say, well, his police complaint is that's sealed. The investigator is not compellable to give testimony or to produce a statement obtained in exercising a power or performing a duty pursuant to this section. So even if he finds evidence contrary to, he finds evidence that's relevant to the complaint, he doesn't have to use it. The investigator is not compellable to give testimony or to produce a statement obtaining and exercising a power or performing a duty pursuant to this section. Subsection 7 does not apply to a proceeding pursuant to this act or a disciplinary code prescribed in the regulations. You see what I mean? He does not have to. The investigator may delegate an employer or agent of the investigator with any powers vested in the investigator pursuant to this section, subject to any conditions that the investigator may specify. So he can appoint people to be anything he wants. Where a public complaint has been resolved pursuant to this part and all the time limits for appeal have expired with respect to that public complaint, the investigator within 30 days shall provide to the commission. That's why it takes so long. It takes 2 or 3 years, right? Then they'll call you up and say, what do you want to do with this? And you say, well, I just really want to forget about it. The investigator writes, the complainant wants to forget about it, sends you a letter saying, well, prior our conversation that you said you just want to forget about it after 3 years, here you go. We forgot about it. Where a public complaint has been resolved pursuant to this part and all time limits for appeal have expired, because that's what they wait for. 2 years to answer your complaint so that nobody can be even held accountable, no matter even if they are held accountable. The investigator within 30 days shall provide a commission report prescribed regarding a resolution of that complaint. Complaint was never resolved, but 2 years has gone by. The commission, so then your complaint is dismissed because the complaint was never resolved in the 2 years of the time limit that's gone by. The commission, with the approval of the minister, may issue written directions to the investigator regarding the general conduct of investigators' duties, but shall not comment on the handling of specific cases. So they won't. Other proceedings not precluded. 40-1. Part does not preclude the taking or continuing of civil or criminal proceedings against a member or chief, except where specifically allowed by this act. Any collective bargaining agreement, bam, it's gone. You see that? So we don't get to know the rest of it. And that's why the public is misinformed, because they do not tell you that all this means is that they have, by contract with the police officer or member therein, chief, etc., have been prescribed to facilitate lawyers, etc., that we've already went through earlier in part 10. Police, this act or any provisions of this act does not apply of any benefit or remedy provided by this act is not available, or any benefit or remedy provided by this act is any way limited or modified, is null, void, no effect. So see, we missed the whole thing. No context for what that says, right? But that means there is nothing. You can't do anything. Reports re-status of the complaint. 41. In case of a public complaint is conduct of a member, the chief shall give notice in writing and complaint of the member complained against and the status of the complaint. To the complainant and the member complained against, the status of the complaint, not later 45 days after the day on which the report is recorded by the person who received it, and every 30 days, which they don't. That's bullshit. After the expiry of the period mentioned in Clause A, during the course of an investigation. They don't do that. They absolutely do not do that. In the case of a public complaint is conduct of the chief, the board shall give notice in writing the complainant and the chief of the status of complaint, not later than 45 days after the day on which recorded, 30 days after the expired period mentioned, 45 days, during the course of the investigation. Notice of expansion or alteration, where a complaint or charge against a member of chief pursuant, this is part expanded or altered as a result of an investigation. The chief or board conducting the investigation shall provide the member of the chief with written notice of that expansion or alteration. Wherein proceeding pursuant to this part are based on public complaint with respect to the member, the chief in consultation with the investigator shall determine whether the complaint or portion of the complaint is a complaint as to the policies and services provided by, so they decide whether you can actually complain right there, the actions of the member. Where proceedings pursuant to this part are based on public complaint with respect to the chief or board, in consultation with the investigator, shall determine whether the blah. It's over. We missed that part because they don't care. Like, I mean, they could put one little, I mean, it's not hard to put a complete document up. It's not hard. It's not hard, but they don't care because you're not reading it. You're not reading it. A public complaint that concerns the policies or services provided by a police service is to be disposed of in accordance with Section 44. The actions of a member is to be disposed of in Sections 45 to 48. The actions of a chief is to be disposed of in Sections 49 to 52. Public complaint as to policies and services. Public complaints, policies and services. Where a public complaint concerns the policies or the services provided by a police service, the chief shall immediately, on receipt of the public complaint, forward the public complaint to the board to be dealt with, considers appropriate, on the disposition of a matter by board pursuant to subsection 1. The board, within 15 days after the disposition, shall give notice in writing of the complainant as to disposition of that matter is subject of the complaint. If they decide that you actually can complain about that part of that, then your complaint can be looked at, but they have to dispose of because they decide whether your complaint is any valid. Investigation. Public complaint as to actions of a member. Where a public complaint is a complaint concerning the actions of a member, the chief, in consultation with the investigator, shall cause an investigation into the complaint to be conducted immediately on receipt of the complaint. Notwithstanding subsection 1 or any of provisions of this part, where the chief and the investigator have the opinion that the public complaint is trivial, frivolous, vexatious, unfounded, made in bad faith, the chief may direct that no investigation be undertaken. An investigation of that complaint is terminated. Where in the opinion of the investigator is advisable to do so, the investigator may conduct an investigation into the complainant, assume responsibility and control an investigation pursuant to subsection 1, or make a report with respect to an investigation pursuant to subsection 1, where the investigator proceeding with subsection 3, investigator shall provide the chief with the written report and where the investigator considers it advisable, consult the chief as to whether that the person being the complainant is charged with harassing the police, for instance. The chairperson or the chairpersons designate on receipt and consideration of a report of the investigator pursuant to subsection 4 may direct the chief to provide pursuant to subsection 48. Where a public complaint is dealt with pursuant to section 2, the chief shall so advise the complainant and the member within 15 days. So if they decide that you're complaining and they don't want your complaint, they don't like your complaint, then they'll tell you 15 days later. Informal resolution, where they force you, they phone you up and they say, hey, come over here, we're gonna sign this or else. You're gonna sign this or else, right? You're gonna sign this or else. That's what they say, right?
You're investigating a complaint. I want you to figure out, and because you know what your solution is.
I do.
And you do know what you're going to do way before you got here. You need to do
I have
that.
an idea. I have an idea.
You need to do that.
What will be right.
That's what you need to do.
Okay.
And all we need is
From my perspective, truth.
Yeah, and the complaint would have been over right there. Would have been over. He should have said, it was Keith Kosher. Keith Kosher's harassing you. We're going to tell him to stop. But now they finally did, I think. I don't know. They transferred him to Carlisle. So I don't know if it'll ever be over. And all we need is the truth. Absolutely. The chief shall consider whether public complaint mentioned can be resolved informally, and with the consent of the complainant and the member concerned may attempt to resolve the complaint informally. He had his pen ready for me to sign there, buddy. Where a public complaint mentioned in subsection 45 is resolved informally, the chief shall cause a record to be made of the manager in which the complaint was resolved. The chief shall cause a copy of the record made pursuant to subsection 2 be furnished immediately to the complainant, the member who is subject to the complaint, investigator who is not directly involved in the formal resolution. A public complaint mentioned in 45 may be resolved informally by the chief in accordance with this section at any time. A public complaint mentioned in subsection 45 may be resolved informally by the investigator, and subsections 1 to 4 apply with any necessary modification to an informal resolution by the investigator. Complaint respecting an offense, notwithstanding any other, after an investigation of public complaint mentioned in subsection 45, a chief or the investigator is of the opinion that actions member may constitute an offense pursuant to the act or an act of parliament. The chief investigator shall refer the matter to the Minister or Attorney General for Canada as the case may be. Boom. We're missing a big section again, right? And the chief, within according regulations, consent of the investigator member who is subject to the complaint, may order remedial action to be taken without charging the member, or so they might say, hey, why don't you guys offer these guys a bunch of money? Where the chief does not proceed pursuant to clause A, the chief shall charge a member who is subject with a minor or major disciplinary offense and order a hearing into the matter as it relates to the contravention, which is very rare. Subject to section 4, where a matter is disposed of pursuant to clause A, the chief, within 15 days after disposition, shall give notice in writing of disposition to member and the complainant. Subject to section 4, where a hearing is conducted for purpose of clause 1B, the complainant has the right to attend the hearing and be represented by legal counsel at the complainant's own expense. The police officers are represented by public prosecution's office at public expense, no matter what they do, and be represented by counsel at the complainant's own expense. So if you go there, remember, you need to have your own lawyer, but is not entitled to call or cross-examine witnesses. So they wouldn't let me call or cross-examine witnesses in my own trial against the police. Must be represented by legal counsel at the complainant's own expense and is not entitled to call or cross-examine witnesses. Wow, see that? You can exclude where the hearing officer is satisfied that's not in the public interest that a complainant attend any or all the part of the hearing officer may exclude the complainant from that or all of that hearing. So you guys get it, right? Do you get it now? Do you get it? Do you get it, guys? Do you get it? Man.